Hello, this is Susheta Sangupta Roy from Swami Vivekananda Institute of Modern Science, Department of Media Science. Today I'm here with yet another tutorial on media laws. And today's topic is Prevention of Sedious Meeting Act of 1911. Now this act is basically a consolidate and amend the law relating to the prevention of public meetings likely to promote sedation or to cause a disturbance of the public tranquility. So basically it will restrict any type of public meetings, any type of any type of meeting which can be serious. And so it is like a law relating to prevention of these type of a public meeting. So this can cause disturbance, this can cause violence, this can cause a lot of unrest in the society. So there has to be, as I always say, that responsibilities and authorities go hand in hand. So if you have authority, you have to have responsibility. So if a person like a citizens of India enjoy the constitutional rights of freedom of speech and freedom of as under Article 19, like we have also we can meet together, and it's like public meetings are not illegal. But then again, it is, as I always say, that if you have authority, if you have constitution as your rights, it has to come with a lot of responsibilities. Now, what are the responsibilities we are talking about? As for the Prevention of Sedious Meetings Act of 1911 says, well, as for this act, it says under section 2 subsection 1 of the Prevention of Sedious Meeting Act of 1911, it says that the state government may by notification in the official gazette declare the whole part of the state in which this act is for the time being in operation to be proclaimed area. So it's like an area can be proclaimed, like in this area nobody can meet. It normally happens during some communal problems, during some elections, or where there can be violence, there can be serious problems. So in that case, that area is proclaimed area, and in that area people cannot concentrate together, they cannot have a public meeting. So section 2 subsection 2 says a notification made under subsection 1 shall not remain in force for more than 6 months. So this proclaimed area will not be there, and you cannot proclaim an area to be this under this act for more than 6 months. It's the maximum validity is 6 months. So but nothing in this subsection shall be deemed to prevent the state government from making any further notification in respect of the same area from time to time as it may think fit. Section 3 of subsection 1 of the Prevention of Sedious Meeting Act of 1911 says that in this act the public meeting means a meeting which is open to the public or any class of portion of the public. That it will be for in an area, it's open to all, anybody and everybody can come in. It can be in a specific area, it can be for specific people, it can be for a specific caste, it can be for a specific creed, whatever. Now, the subsection 2 of section 3 says a meeting may be in public meeting, notwithstanding that it is held in a private place and admission thereto may have been restricted by ticket or otherwise. So even if it is in a public meeting which is on like a ticket or entry to invitation or whatever, the rules are applicable if it is under the proclaimed area. So under section 4 subsection 1 of the Prevention of Sedious Meeting Act of 1911 says that no public meeting for the furtherance or discussion of any subject likely to cause disturbance or public excitement, or for the exhibition or distribution of any writing or printed matter related to any such subject shall be held in any proclaimed area. So if it's a proclaimed area, no discussions, no disturbances, no public excitements, not even that you cannot write things or print out material and then you distribute within the public, you gather people and then distribute some pamphlet. You're not talking, you're just distributing pamphlet. No, if it's a proclaimed area, nothing of that sort can be done, because even that will be as a public, it will be taken as a public meeting. Now, so section 4(1) A says, unless written notice of the intention to hold such a meeting and of time and place of such meeting has been given to the district magistrate or the commissioner of police, as the case may be, at least 3 days previously. So even if it's really required, suppose like the pandemic situation, or sometimes there's a flood or something like a cyclone, and somebody has to distribute the do's and don'ts, that if you see a naked wire in the road, please don't step out. If it is watery, you may get electrocuted. So these are the specific awareness programs. Now if somebody wants to do that within that proclaimed area also, that person can obviously take a permission or seek a permission from the district magistrate or the commissioner of police 3 days prior to the intended meeting. And if the permission is granted, they can obviously go for it, and in that case, that meeting will not be taken as the Prevention of Serious Meeting Act, and that will not be covered under this act of 1911. Now so under this the section 4 subsection 2, the district magistrate or any magistrate of first class authorized by the district magistrate in his behalf by order in writing depute one or more police officers not being below the rank of head constable or other persons to attend such meeting for the purpose of cause a report to be taken for the proceeding. So if there is a problem, this proceeding can be taken. So if district magistrate or the magistrate of first class who is like authorized for the district magistrate on his behalf by order of writing depute one of the police officers, by writing they can depute a police officer, but the police officer cannot be below the rank of a head constable to attend such meeting, because that meeting can be attended by that person to take care or to check whether the meeting is the purpose of the meeting, what they have said to the commissioner or to the district magistrate is being is the reason they have said is right, or they are misusing the opportunity. So to take care of that, a police officer not below the rank of head constable can be deputed by the district magistrate. Now, the Prevention of Sedious Act of 1911, subsection 5. That is section 5, sorry. Section 5. So, district magistrate or the commissioner of police, as the case may be, may at any time by order in writing or which public notice shall forthwith be given prohibit any public meeting in a proclaimed area if, in his opinion, such a meeting is likely to promote sedition or disaffection or to cause disturbance to public tranquility. Now, if the district magistrate thinks that even after a permission is sought, but the district magistrate thinks that that meeting can cause a sedition or any type of disturbance, any type of violence, any type of disaffection or public tranquility, then the district magistrate will obviously prohibit such type of a meeting. He will not give permission for it. So it's very, very strict, because end of the day, peace and harmony is so important in our country. We are a peace-loving country. Now, Section 6, subsection 1 of the same Act, the Prevention of Serious Meeting Act of 1911 says, any person concerned in the promotion or conduct of a public meeting held in a proclaimed area contrary to the provision of Section 4 shall be punished with the imprisonment for a term which may extend to 6 months or with fine or with both. Now, suppose somebody does not take permission from the magistrate, from the police commissioner, and go for a meeting and does a public meeting in a proclaimed area, so that person can be imprisonment up to 6 months with fine or with both. It can be 6 months or with fine, or with 6 months plus fine. Now, it's like Section 6, subsection 2 says, any public meeting which has been prohibited under Section 5 shall be deemed to be unlawful assembly. Now, subsection 5 says that if the district magistrate or the commissioner of police thinks that a meeting has been asked for, a permission for a meeting is asked for, but even if the permission is given, there can be disturbance or public tranquility or disaffection or sedition or violence or any type of thing in that, and the permission is not granted, but still they go for a meeting. Still, the person who have just applied for a permission, they do a meeting, in that case, that meeting or that assembling of people will be taken as an unlawful assembly, and it is a criminal suit. It will be a criminal case, and that will be filed in the court of justice for further proceedings. So this is all about the Sedious Meeting Act of 1911. So thank you so for now, and I'll be back again with some other details or some other tutorial on the media laws. Till then, stay blessed.